administration of the estate. And when we speak about expenses, we mean the initial costs that will be required for consulting with an attorney, and that process involves certain legal requirements that requires an expense. And in doing so, the executor will be entitled to compensation through the estate, but it's important that we pay attention to that fact so that whoever we choose will be the right person that has the responsibility to do these things and also has access to funds to ensure that this can be done in their role.
Because some of those legal requirements include advertising in the paper. I know sometimes you get to the back of the paper and you see a estate of this person, and you're probably wondering, like, what is that? That is probably persons that had a will or did not have a will, and you have a legal requirement to advertise to persons that have an interest in your estate. So it might definitely be those persons that you owe that say, oh, you died, so now I need to claim my debt. And so advertising in the paper, you have that as a cost. And so a person needs to know up front, I may not be able to acquire it right away from the estate. I need to pay for this out of pocket and be reimbursed later.
We will also speak about revocation. That is also a step that persons are necessarily aware of. And one of the things that can revoke any will is if you are newly married. So any new marriage revokes your will. So if you have a will right now and you intend to marry, it's important that you recognize that it can revoke your previous will unless you make some stipulation in your current will as to the fact that you're anticipating marriage and that, on the marriage, you expect the assets to be distributed in a particular way. So be mindful of any new marriage and the impact that it will have on a previous will.
Also, any new will take precedent over the old will. So if you do a will today and another one tomorrow, the one tomorrow will take precedent over that old one. So automatically, any new will would make that old one invalid.
Also, destruction of your will can also revoke that will. So destruction, if for instance you created a will and you take the original, you rip it in half, you tear it apart, you burn it in fire, that is a form of revocation of your will.
Or it could be one of the beneficiaries found that original will, didn't like what it said, and tore it in half.
Those are certain risks that do occur. But there are certain applications that can be made in court for any previous will that was destroyed to be declared as valid. And there are certain steps, and the burden is very high to prove that the intention of the testator was not to destroy the will or to revoke it in any way.
Right, so we always advise our members when they're coming to do a will, sometimes it's best to have it lodged at the Supreme Court for safekeeping. And we always give you a copy. So you have your copy at home, but your original will is safe until you're ready to do a new one. So you've got a new asset, you want to add it on. Your new one is safe. Say, God forbid, you had a hurricane, a fire, your original will be safe. Now, what if you don't do a will? Does anyone know that if you don't do a will, what will happen after your death? Chaos is one of them. But really, the law makes an assumption of what you would have wanted to do with your will. So them in considering the nieces and nephews that you wanted to take care of, they're not going to assume that you wanted to take care of a godchild. They're going to make certain assumptions. And these assumptions are, I'm going to give you a list of the priorities. If you are married, you have a spouse, and you have no children, your spouse is entitled to your whole estate. Your spouse meaning your husband, your wife, or your common law wife or husband. So even though you may not be legally married, you might be common law married. You've been living for a while together. You're considered legally married. Yes, 5. 5 years or more, living together as husband and wife. So even though you did not stand in front of a pastor and you didn't sign a marriage certificate, you will be as good as if you had did that. So the law considers that spouse, if you did not have any children, fully entitled to your estate. Now, if you have children and you have a spouse, so you only have one child and a spouse, your spouse will be entitled to 2/3 of your estate, and your child will be entitled to 1/3.
When she says child includes child by blood or even adopted children.
formally adopted children.
Yes.
So I know that we live in Barbados where you feel like I raised you from young and you belong to me. That is not your child if you do not go through a formal process to adopt that person. So the law will not recognize that person as your child because they did not know that you took them in as a baby. Additionally, is if you have a spouse and more than one child, your children will be entitled to split the 2/3, and your spouse will be entitled to that third. Right, so if you have more than one child and a spouse, your children will take the 2/3. So if you have 10 children, they're going to split that 2/3. And your spouse will be entitled to that third. So the law will not know that you and your husband were not agreeing just before you all died, and you ain't really want him to get anything. Right. Also, if you don't have any children, or you are not married, whether common law or legally married, it will go to your parents. If your parents die before you, it will go to your siblings.
So
they will look for the closest blood relative to you. So that person will have to say, that is my great auntie, niece.
or the government will take it.
Yeah.
That is also the risk.
Right, so if you feel like you do not have anyone close to you like that, close relative like that, and you do not want the government to make I don't know about y'all, but I don't want nobody making assumptions about what I would want to do. You want to make sure that, listen, I may not have had a spouse, I may not have had children, but I have a goddaughter that I love dearly, and I would like her to get something. The law does not recognize her. She is nowhere on this listing.
I'm sorry, the dog does not meet the requirement.
No, your dog does not meet the requirement to hold an asset.
As Shanna mentioned, in order to ensure that the persons you want to get the benefit of your estate actually gets that benefit, it's important that you do the things that you can when you can. As Shanna mentioned, informal adoptions of children. In that case, there's nothing in formal records to show that this person is your child. If you want to ensure that you take care of them, you must ensure that you create some kind of system so that they will benefit from your estate when that time comes.
We also have to mention that, say you don't have a spouse, but you have children. The law assumes that you would want your children to split it equally. But we all know that some children be disgusting. And you don't want them to be sharing nothing equally. You would like that, you know what, you have been disgusting. You have, I still want to leave you a little something, but not as much as my other son that has blossomed. So I would really like to give you 2/3 and him a third. If you do not put anything in place, they can take that same disgusting one and loop him with the good one. And you don't want nobody making that assumption, because who would know?
Suppose you were married before you had 2 children, and one died or the husband died, but you got outside children now.
Children are children, inside or outside.
Yeah. Once they can prove that that was their parent, their father, yes.
But also on the fact of children, many times something that we forget is to ensure that our father is actually inserted onto our birth certificate. Because there are many instances where persons attempt to probate not probate a will, but do letters of administration in the event of not having a will, and they're trying to prove that they have the entitlement to apply. And when they produce the birth certificate, their father is not listed there as being their parent. So that puts a damper on the process, and they have to take a further step, which will be an expense, to have a declaration be done through the courts that the deceased father is actually their father.
And no one wants to have to go to court and put it in writing to say, well, this is the person that has raised me, this is my father, having to get witnesses to say, yes, I know John Brown to raise Susie, just because their name was not on your birth certificate. So that all comes into assessing those circumstances that we mentioned. You're going home and you're looking and say, listen, Daddy getting down, and Daddy name not on this birth certificate, so I really need to take some steps now that he's alive to have his name included on my birth certificate.
this occurred a lot more in the older days, but I also have seen this happen in the current time where parents don't insert a father's name on their birth certificate. So we might make the assumption that it is there, so we urge you to ensure that you check to make sure that that is the case. I know we spoke a lot about wills, but now we're moving on to another important document, and that is a power of attorney. We mentioned before about ensuring that we do things in our lifetime that will better take care of our estate and also protect our assets in some type of way. And we believe that a power of attorney will assist in doing that. A deed of power of attorney is simply a written authorization to represent or act on another's behalf in private affairs, business, or some other legal matter. So in other words, or in simple terms, you might want something to be done on your behalf, and you really are unable to do so. For some reason, you might be abroad, you might be incapable physically. You can appoint a person to act on your behalf to do particular transactions.
Right, so there are two main types of power of attorneys. There's a general one, and there's a limited one.
Okay.
A specific one. Right. So I call it a limited one because it's very limited on what you can do for a particular person. The general one, as the name suggests, it allows a person to do generally anything that you can do. It literally has that wording in the document. Generally anything that I can do in my own name, this person can do on my behalf. So we always advise that when you are putting a general power of attorney in place, make sure it is someone that you trust. Right? Because they can do anything that you can do. They can sign as you. Anything in your name, they can do. They can go and withdraw on your account. They could go and buy land in your name. They could apply for loans in your name. Anything that you can do, a person can do once you have given them the power under a general power of attorney. The limited one now may be, I just want you to be able to access some funds for me while I'm abroad. You can put that limited one and you're going to say, I just want him to be able to withdraw. It could be for a particular time. It could be a particular amount.
Particular account?
Yes. And you want to just limit that person to that. I don't want you to be able to go and buy no house. I don't want you to apply for no loans. I just want you to be able to access this money. I just want you to be able to sign this document on my behalf because I'm not physically able to do it.
Now let's speak about the legal requirements. You mentioned before, in order for a will to be valid, you must have the mental competency to do so. It's the same case with respect to a power of attorney. And even if you would have created it when you were well and able to do so, when you lose your mental competency, it therefore invalidates the power of attorney document. So that means it's no longer valid.
I always say you must always be able to say, I no longer want this anymore. Right? So once you lose the ability to say, I no longer want a power of attorney in place, your power of attorney has been revoked.
It also must be in writing and signed by the person who is granting the power of attorney to another person. And that factor on having the mental capacity to do so, we see many instances where persons, I would say, I guess it will come from a place of uncertainty. They're not sure, they did not know that from the time a person loses their mental competency, that they cannot perform transactions under that power of attorney. The step that is required to be taken is what we call a receivership order, where the court appoints a guardian to ensure that the person who does not have the mental capacity can be taken care of.
Right. So you always must be able to say, I no longer want this power of attorney anymore. So it's automatically revoked upon your death or upon you losing that mental capacity.
Exactly. And when we are putting these things in place, we mentioned before ensuring that persons you trust are in these particular roles. Persons abuse these documents daily. And we try our best to ensure that it is not done, but there are some persons, some of us, we wouldn't really be able to control at all. So it's important that you either limit your power of attorney or ensure that persons who have the general power of attorney are persons in your life which you can trust and you can guarantee will do what is required.
So some people do abuse it, but some people really do not know. In terms of you may not know that it does not continue after a person's death. A person has died, you need to start getting some money for the funeral, and you decide, hey, I was given a power of attorney, I could go and withdraw. No, you cannot. It is automatically revoked upon the person's death.
All right, so we spoke a lot about various decisions which you can make in your lifetime, and some of the estate planning decisions which you can make, the credit union offers to you. And that includes the preparations of wills or power of attorney services. It also includes opening accounts. It also involves the process of applying for loans so that property can be purchased. And it also includes the premier plans, as Harriet would have mentioned in her presentation. And all of these things